Welcome to the deep dive. If you are tuning in right now, you are probably right in the thick of prepping for your professional planning exam.
And honestly, that is a massive undertaking, but you've totally got this.
You do. And our mission today is to tackle something that is, well, it's just an incredibly important piece of the puzzle for you.
Absolutely.
We are going to be focusing on a specific article from the spring 2019 issue of Planning West. It's by Guy Patterson, who is both a registered professional planner and a lawyer, which is a pretty powerful combo for this topic.
Right. And the topic is a brief overview of the duty to consult.
Exactly. And just to give you some initial analytical framework before we get to the weeds, the sources we are looking at today contain some major legal precedents.
Yes, specifically decisions from the Supreme Court of Canada.
Right. And these decisions fundamentally define the relationship between the Crown and First Nations. So as a planner, you really can't ignore this.
No, you can't. It dictates the boundaries of how government decisions are made regarding land and resources.
Okay, let's unpack this. Because the author makes a really interesting observation right out of the gate about a major paradigm shift in planning.
He does. He talks about attending a UBC Planning Student Symposium.
Right. And he noted that if you went to planning school maybe 10 or 15 years ago, the dominant buzzword, the thing everyone was talking about, was sustainability.
Yes, sustainable development, green infrastructure, all of that.
But now, reconciliation absolutely tops the agenda in planning schools.
And for good reason. But we need to define what reconciliation actually means in this specific legal and planning context, based on Patterson's article.
Because it's not just a buzzword.
Exactly. Legally speaking, it boils down to the fact that the Crown has a duty to consult and, in some cases, accommodate First Nations.
Which directly impacts your future career.
Right.
So for your exam and just as a future planner generally, you cannot shy away from this challenge.
You really can't. Understanding this duty is foundational to your everyday work. It's going to affect zoning, permitting, infrastructure projects, you name it.
So getting into the foundation of this duty, I was fascinated by a key distinction the author makes about where this rule actually comes from.
That's a huge point.
Right, because if a local government has an obligation to hold public hearings for a new zoning bylaw, or if the province sets out rules for cannabis retail, that's all written down in legislation.
You can point to a specific statute or act.
Exactly. But the duty to consult First Nations, the author points out that this is almost entirely judge-made law.
And the significance of that for your exam cannot be overstated. There is no single piece of legislation codifying exactly when or how the Crown must consult and accommodate.
There's no handbook passed by Parliament that gives you a neat little checklist.
Right. It has evolved through the courts.
Right.
But it is anchored in the Constitution,
Yep.
Specifically Section 35(1) of Canada's Constitution Act 1982.
And for those taking notes, what exactly does Section 35(1) do?
It explicitly recognizes and affirms existing Aboriginal and treaty rights.
Right. But the text makes a really important geographic distinction here, specifically for British Columbia.
Yes. In northeastern BC, the land is covered by Treaty 8. So those rights are formally laid out in a treaty document.
But in the rest of the province?
In the rest of the province, Aboriginal groups have historically had to prove the existence and extent of their rights through the courts or through modern treaty processes.
Because the land is unceded.
Exactly. And the result of all this judge-made law and Section 35 is that the Crown simply cannot make decisions that affect those rights without first consulting and sometimes accommodating those First Nations.
Even if the rights aren't fully proven yet in court, right?
Yes, and that leads us directly into the first major Supreme Court decision you need to know about.
Right, the Haida case. There are two companion Supreme Court of Canada decisions from 2004 and 2005 that the article focuses on. The first is Haida Nation v. British Columbia, specifically the Minister of Forests.
This is a landmark case from 2004.
So let's lay out the facts for you. This case involved an infringement on an asserted but unproven title to land. The province was issuing and transferring logging rights on Haida Gwaii.
And the Haida Nation objected, arguing they had title to that land, and the logging was infringing on their rights.
But because their title was asserted and hadn't been formally proven in court yet, the province argued they didn't actually earn a duty to consult.
Right. The province's stance was basically, we don't owe you a legal duty until you prove you own it.
And the trial judge actually agreed at first, right, calling it just a moral duty, not a legal one.
Yes, the trial judge said it was a moral obligation. But it went all the way to the Supreme Court of Canada, and the SCC ruling changed everything.
They said it'd have legal duty.
Exactly. The court ruled that the legal duty to consult exists even before rights or title claims are formally proven.
And this brings up a concept you absolutely need to highlight for your exam prep.
What's fascinating here is how the court justifies this. It all stems from a concept called the honor of the crown.
The honor of the crown. I love this part of the legal analysis.
It's so deeply rooted in history. This concept arises because the crown asserted sovereignty over people who never actually acquiesced to it.
They were never conquered.
Right. And they haven't reconciled via treaties in most of BC. So because the crown essentially imposed its sovereignty, it must act honorably in all its dealings with Aboriginal peoples.
It's a constitutional principle.
Oh.
And there's a fantastic quote from Chief Justice McLaughlin in the source material that really drives this home.
I know the exact one you mean.
She said that to unilaterally exploit a claimed resource while a claim is being resolved deprives the Aboriginal claimants of the benefit of the resource. And she explicitly states that is not honorable.
Which is such a powerful legal standard. You can't just log the forest while the title dispute is stuck in court for decades, leaving them with nothing if they win.
Right. It forces the Crown to engage right now, today. So that's the why, and the when, the duty to consult from the Haida case.
But then we have to talk about the how.
Exactly. How do you actually do the consulting? And that transitions us to the second massive Supreme Court decision. Mikisew Cree, First Nation v. Canada, specifically the Minister of Canadian Heritage.
This one came out in 2005, right on the heels of Haida.
And the facts here are different. This was an unproven title. This involved the infringement of established Treaty 8 rights.
Right, the rights to hunt, trap, and fish.
And the government wanted to construct a winter road right through the Mikisew Cree First Nations reserve lands.
Well, through their traditional territory where they exercise those treaty rights. And the government went into court with three main arguments to try and defend how they handled the project.
All three of which failed spectacularly.
Totally failed. First, they argued the road didn't actually infringe on the treaty rights.
The court didn't buy that.
Second, they argued that their duty to consult was already discharged way back in 1899 when Treaty 8 was originally negotiated.
Imagine trying to use an 1899 meeting to justify a modern winter road.
Right, and their third argument was that the consultation process Parks Canada used was sufficient.
And here's where it gets really interesting, because you need to know exactly how Parks Canada messed this up.
It is a cautionary tale for planners everywhere.
So, Parks Canada essentially treated the Mikisew Cree like they were just part of the general public of interested stakeholders.
Yes, they lumped them in with everyone else.
They sent them standard information packages and invited them to open houses.
And the Mikisew actually declined to attend those open houses. They stated clearly that an open house was an inadequate forum to address their constitutionally protected treaty rights.
Which makes perfect sense. They aren't just an advocacy group. They hold rights recognized by the Constitution. But Parks Canada proceeded anyway.
They did. They apologized later, but they basically approved the road without any specific reference to the Mikisew's concerns.
So what did the Supreme Court have to say about that?
Oh, it was a very sharp rebuke. The court reminded the government that this consultation process takes place in the shadow of a long history of grievances.
It's not a blank slate.
Exactly. And the court pointed out that the lack of respect and the indifference shown by government officials in this case was highly destructive to the process of reconciliation.
The author has some very memorable phrasing here for the listener to remember for the exam.
Yes. The court made it clear that consultation is not just an opportunity for First Nations to blow off steam before a decision-maker just goes ahead and does what they intended to do all along.
Blow off steam. I mean, that really paints a picture of how public engagement is sometimes run, unfortunately.
It does. And the court is saying that when it comes to Section 35 rights, that attitude is completely unacceptable. It demands something much deeper than mere public consultation.
So that leads to a very natural follow-up question. If a standard open house isn't enough, what exactly does the court demand? How much consultation is enough?
Well, because this is judge-made law, the court uses what they call a sliding scale or a spectrum approach.
A spectrum of consultation and accommodation.
Right. There is no one-size-fits-all answer. The scope and nature of the consultation vary depending on two main factors.
Okay, what are they?
First, the potential impact of the decision. Is it a minor administrative change, or are you clear-cutting a forest?
Makes sense.
And second, in cases of unproven rights, like in Haida, the strength of the claim. How strong is the preliminary evidence that they hold title to this land?
So high impact and a strong claim means deep consultation.
Exactly. That might involve formal participation in the decision-making process, funding for the First Nation to do their own environmental studies, or significant accommodation to alter the project.
But what about the lower end of the spectrum? What if the impact is relatively minor?
Even on the lower end, the Crown must do more than just give notice, wait for a response, and then move on.
So no rubber stamping.
No.
Yeah.
They must actively solicit and listen to concerns. They have to genuinely take those concerns into account, and they have to attempt to minimize adverse impacts.
That active listening piece seems crucial.
It is. If we connect this to the bigger picture, the entire framework is about balance. The court has been clear that the duty to consult never amounts to a First Nations veto over a project.
It's not a duty to agree.
Right, there's no duty to reach an agreement, but it absolutely requires a process of balancing interests. There has to be give and take.
And it cannot admit the indifference that we saw in the Muckasu case.
Exactly. The Crown must show that it seriously considered the perspective of the First Nation and tried to integrate it.
So what does this all mean for the listener? You are prepping for your exam, you are looking at your future career.
Well, as the author points out, to a professional planner, a lot of this probably sounds like standard best practice anyway.
Yeah, proper notice, meaningful engagement, careful listening, that's just good planning.
It is good planning. But the vital distinction you need to make on your exam is that in this context, it is grounded in the honor of the Crown. It is a constitutional necessity, not just a professional courtesy.
And despite these rulings being from 2004 and 2005, the author notes we still have a lot of room for improvement.
We do. He cites two recent federal Court of Appeal cases, recent at the time of publication anyway, where the Crown still failed to adequately consult.
The Slilewat Notion v. Canada case regarding the Trans Mountain Pipeline.
Yes, and Morton v. Canada, which was about finfish aquaculture.
In both of those massive cases, the courts found the Crown's process was insufficient.
Which just proves that government bodies are still struggling to translate these legal principles into adequate administrative processes.
Wow. Okay, so we've covered a lot of ground today. First of all, congratulations to you, the listener, for mastering this dense but totally vital material for your exam.
You are going to do great.
We tracked the core journey today, starting with a paradigm shift from sustainability to reconciliation in the planning profession.
We covered how this is fundamentally a judge-made foundation anchored in Section 35 of the Constitution.
We looked at the Haida case, establishing the legal duty even for unproven claims grounded in the honor of the Crown.
And we broke down the Muckasu case, which firmly rejected the idea of treating First Nations like the general public or just letting them blow off steam.
Before we wrap up, what is a final provocative thought you can leave the listener with? Something to ponder for their exam and their career.
Well, given that the duty to consult is judge-made law that continues to expand and refine through court challenges, I think the real question for a future planner is this. How might the everyday tools, the standard applications, and the strict timelines of your job need to proactively adapt?
That's a great question.
How can you build a planning process that anticipates the honor of the Crown from day one rather than just reacting to the latest court ruling after the fact?
That is definitely something to chew on as you study. It's about getting ahead of the curve, not just do the bare minimum. Thank you so much for joining us for this deep dive. Good luck on your exam. You're going to absolutely crush it.
Best of luck.